And the last thing, which is bottom part of 28 and just at the top of 36, the parents have the right to appeal student record content. In other words, if they ask for something to be expunged, then they have the right to do that. Don't worry too much about the top of the page grading of papers. And we're moving to chapter 5. We only have 2 more to go, and we'll go pretty fast. So you want to stretch or fire on? We don't want to. Okay. Chapter 5, page 37 in the green book, 31 in the purple book. Most religious expression and curriculum issues. These most religious expression and curriculum cases are argued before the federal courts, and they may ask you a question about that, not by state courts normally, because they deal with the Bill of Rights. And of course, that's the First Amendment. You should all know that the First Amendment is the one that guarantees freedom of religion and separation of church and state, freedom of speech, freedom of the press, freedom to assemble. So the first case down is basically right at the turnover of page 38 in your green book, and at the bottom of 31. This is the case of the Church of the Holy Trinity versus the U.S. And it does note that the government preference for Judeo-Christian values was frequently cited in historical documents by the U.S. Supreme Court. And then it goes on to say that it was also stated in many state court cases. So this is just giving you some background that up until after World War II, they really weren't concerned about separation of church and state. At the bottom, middle of page 32 and near the bottom of 38, the Oregon Socialization Law, Pierce versus Society of Sisters. Oregon passed a law that said that all students must go to public schools. So the Society of Sisters ran a parochial school. They sued, said that's a violation of our freedom of religion, because people who go to our school because of their religion go there. And the Supreme Court decided unanimously in their favor, and so said that you can't require everybody to go to public schools. And that's been brought a great deal. Separation of church and state is big. The Everson case at the top of 33 and a little bit down on page 39 in the Green Book, the Everson case and Reynolds versus the United States, which was a decision before that, continually quoted the Thomas Jefferson, who said we should build a wall of separation between church and state. And then it talks later down about the Abington case, which ended school-sponsored prayer and Bible reading. So you should be aware of those cases. The details aren't that important. A third case, which is also significant in addition to Everson and Abington, is Engel versus Vitale. Engel, which is down just over the summary of Abington and Engel, talks about Engel, and that outlawed the state-sponsored or school-sponsored prayer as unconstitutional. And so the summary is right down there, and I think that's important. The summary of those decisions is that it may not be taught devotionally. In other words, Bible reading or anything like that may not be taught devotionally. They may be used in a historical context or may be used in literature. So I have no idea how you can teach history without talking about religion and what effect religion has, and literature the same way. The Lemon test is a test, it was a case that by the Supreme Court, which set a three-pronged test, really, a test for church-state separation. So if you go down and skip that first paragraph, the second paragraph, which starts off the longer and lasting legacy of the case, and that would be the 3 points they make, A, B, and C there. It outlawed government involvement in activities if it did not have a secular purpose, I mean, a non-religious purpose. If there was just a religious purpose, that was not allowed in public schools. Secondly, it advanced or inhibited religion. And third, it fostered an excessive government entanglement with religion. Let me start going through the decision a little bit. That's Lemon versus Kurtzman, which is commonly known as Lemon. Significant church-state cases on page 34 at the top of 41 in the Green Book. The Bowen case said that that there could be public funds for religiously oriented teen sexuality program, which would benefit the kids. The courts have had a whole series of cases where if it doesn't say the school district has to do it, but like providing bus transportation, textbooks, other things like that. The court said if the school district wants to do it, then that's okay. It benefits kids, so the kids are there. So that's basically it. It outlines the Lemon test down in the middle of that, but you just have to know what the Lemon test is. Lee is that's again near the bottom of 34 and the purple 41, about the middle in the green. Lee school-sponsored invocation and benediction. It outlawed school-sponsored invocations and benedictions, because it was depriving people who did not believe in any religion, it would offend them coming to graduation. So that case is pretty much held up. Lamb's Chapel case is an interesting case in that it sort of takes a different look at the idea of separation of church and state. It allows religious activities to use public facilities. It used to be that schools, city, county offices or buildings, auditoriums, would not allow religions in there because they thought it was a violation of separation of church and state. But what Lamb's Chapel did was it then said that as long as the school or whoever owns the facilities is giving equal access to everybody, there's no reason why the church can't do that too.
15 seconds. Is that good?